I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series detailing the OTCQX listing requirements. To be eligible to be quoted on the OTCQX International, companies must have $2 million in total assets as of the most recent annual or quarter end. As of the most recent fiscal year end, have at least one of the following: $2 million in revenues, $1 million in net tangible assets, $500,000 in net income, or $5 million in global market capitalization, all in US dollars. The company must meet one of the exemptions in Rule 3A 51-1 to the penny stock definition. That is, the company cannot be a penny stock. As with a U.S. company, the company can satisfy this requirement using pro forma financial statements signed and certified by the CEO or CFO and posted through EDGAR or on the OTC Markets website. The company must be quoted by at least one market maker on the OTC Link and have an active 15C211. The company cannot be a shell company or blank check company, cannot be in bankruptcy or reorganization proceedings. The company must have a minimum of 50 beneficial shareholders owning at least one round lot each, which is 100 shares. The company must have a minimum bid price of 25 cents per share for its common stock as of the close of business on each of the 30 consecutive calendar days immediately preceding the company's application for the OTCQX. If there has been no prior public market for the company's securities in the U.S., FINRA must have approved a Form 211 with a minimum bid price of 25 cents or greater. If the company is applying to the OTCQX immediately following a delisting from a national securities exchange, it must have a minimum bid price of at least 10 cents. The company must be included in a recognized securities manual or be subject to the reporting requirements of the Exchange Act. The company must have its securities listed on a qualifying foreign stock exchange for a minimum of the preceding 40 calendar days. However, OTC markets can grant exemptions for companies trading on other foreign exchanges as well. The company must have a global market capitalization of at least $10 million on each of the 30 consecutive calendar days immediately preceding its application day. The company must meet one of the following conditions: be eligible to rely on the registration exemption found in Exchange Act Rule 12G 3-2B and be current and compliant in such requirements, or have a class of securities registered under Section 12G of the Exchange Act and be current in its SEC reporting requirements, or, if not eligible to rely on the exemption from registration provided by Exchange Act Rule 12G 3-2B and is not otherwise required to register under the Exchange Act, it must be current and fully compliant with the obligations of a company that is relying on 12G 3-2B, and it must have a Principal American Liaison, or PAL. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.